Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. Today we are going to discuss a case law on Motor Vehicles Act MV Claims Tribunal. Normally, you will file a claim petition under section 166 of the MV Act. Of course, you know the appeal provision also 173 of the MV Act. Actually, this is decided by the High Court of Kerala, single judge, under section 173 of the ME Act. The main contention, Kerala High Court has evolved twin rules or twin points or 2 points theory to fix up or to gain compensation in any insurance case or to gain compensation in the claim. So this is a twin theory or twin conditions they have taken. While disposing the case of Oriental Insurance Company versus V. Babu and others in MV Claims Appellate number, Appeal number 350 by 2012, disposed on 31st May, 10th June 2022. Single judge Bashiruddin, he held that there should be the twin conditions to prove the so-called accident or negligence on the part of the driver. First of all, let us know what are these two conditions, because that is the crux of the judgment. Number one, that the accident is due to the negligent or rash driving of the driver. First point, this everybody knows, but please remember why the court has emphasized on these points. By the end of this video you will be able to understand. The first point is, yes, there should be negligence on the part of the driver and the incident should happen. Second point is, the injuries, the cumulative effect of the injuries or the death should result with the injuries caused due to the accident. So whatever injuries were caused in the accident, they should cause the death. That means the person should succumb to the injuries, not otherwise. That means the judge should not get any doubt as to how the injuries are caused or whether these injuries are sufficient to cause the death of the person. These 2 points are important. Now we'll go to the facts of the case. Very simple fact. So Babu's wife was traveling on a motorcycle driven by her brother. The accident happened, due to which she fell down. She received injuries, but no FIR was registered. The FIR was registered after 3 months. No postmortem was done, but they claimed compensation from the owner, from the driver, as well as from the insurance company. Suppose if you are the advocate on behalf of the insurance company, will you agree? Definitely no. But the tribunal, that is actually the MV Claims Tribunal, that is ADJ, he opined that there was an accident, that these insurance people, they have to pay compensation. But aggrieved by this, the insurance company filed an appeal under section 173 of the MV Act before the Honorable High Court of Kerala. Now the matter has come before the Kerala. So basing on the twin points theory, twin conditions, High Court of Kerala opined that they could not prove the case. This is the main point. Now you will hear the arguments on behalf of the insurance company, that is the appellant. Appellant says, Your Honor, no accident took place because there is no FIR. There is FIR. The FIR was registered after 3 months, not immediately. Second point, no postmortem was done. We don't know as to whether the injuries are sufficient to cause death, whether the death occurred due to injuries or not. So these two are glaring anomalies in the cause. No doubt, even the deceased, on behalf of the deceased, it was argued that on the day of incident, they approached the police, that the police said, come on, since he is the relative, you wait and see. If you have to compromise, it's okay. Otherwise, we'll take up the case. Like that, they have dodged the matter. And the matter ultimately has to be registered on the pressure on some pressure, ultimately after 3 months. Therefore, the delay in the FIR, they say that it has been explained, but of course, by the time the body was already burnt, the body was already disposed of, so no post-mortem examination. So the High Court of Kerala clearly opined that since these twin conditions are absent, then we can't award any compensation. So Oriental Insurance Company is actually successful in the appeal and they need not pay any compensation. So friends, remember, you have to advise the gullible public in this particular connection. Normally, the police may not register the FIR, so you have to pressurize your client to go to the police station and get a copy of the FIR. That is more important. And secondly, post-mortem exhaustion. So many people, of course, nowadays it's a little bit change is there, but previously, when we worked in the police force, they used to take the body without post-mortem examination. They used to say, ఆల్రెడీ మా వాడు చచ్చున్నాడు సార్, బాడీ అంతా ఇదైపోయింది, మళ్ళీ దాన్ని ముక్కలు కోస్తారా, ఎందుకు అక్కర్లేదు ఇది అంటారు. తర్వాత క్లెయిమ్కి వచ్చేటప్పటికి దట్ ఈస్ అన్ ఇంపార్టెంట్ ఇష్యూ. So these two things you must enlighten the general public also. Of course, you must be careful while dealing with such cases. So please read the case law and enrich your legal knowledge. Thank you very much.